Let me introduce the guests today. This is Susan Riedel. She is a longtime former assistant district attorney in Las Cruces and a Republican. And we also have Hector Balderas, who's a Democrat, who is the current state auditor. Even though the state attorney general is one of the highest statewide elected offices in New Mexico, I think a lot of voters aren't really sure what exactly the AG does. So Susan, I want you to start by telling people, what do you feel like is the most important part of the AG's responsibility?
Well, you know, there are so many responsibilities. Picking one that's important, I think, is tough. One of the things that I think people need to realize is that it is the top cop of the state. So that means every time your local district attorney prosecutes a case and convicts a criminal of a crime, that appellate case goes into the Attorney General's office and becomes completely under the control of the Attorney General's office. The district attorney no longer has say-so in what happens. I want to fix that, and I want to make sure that there's good communication between the DAs and the Attorney Generals that are handling those appellate cases. In addition to which, you're the lawyer for all the major agencies in the state. So for the governor, for the cabinets, you provide the attorneys that provide advice to them, as well as provide advice yourself to all of those agencies, which is really important because you can have a great effect on how those agencies behave or don't behave, depending on what you're doing. And so I think those are really the major things. They have a large consumer affairs division, consumer protection role in the state, and that is not so much from the legal point of view as far as lawyering, but from making sure that as the protector of the state and the representative of the people around the state, that they're protecting consumers from fraud, and that they're making sure that businesses are also being protected from false allegations.
You know, I think we also philosophically sometimes differ on how we interpret those functions. For me, the top priority is to be the people's lawyer and to really make sure that it is a Department of Justice. And not only is that required in state law and in Constitution, but what's exciting about the Attorney General is he or she gets to determine what truly is in the state's interest and what should be those priorities. And for me, it's going to be protecting families, making sure that we are attacking the biggest risks impacting all families in New Mexico, and also looking and making sure that their rights, their privileges, their civil rights are being respected, and that we make New Mexico one of the great places to really live and prosper.
I want to talk a little bit about the relationship between the higher offices in New Mexico. You both mentioned those briefly. We've seen that when the Attorney General and the Governor are from different political parties, sometimes there's tension that makes it hard to really get anything accomplished for the people of New Mexico. So I want you to talk about how will your behavior or your policies change if you're serving as Attorney General with a governor of your own party or of the other party?
I kind of fancy myself at looking at past leaders, and ironically I kind of thought the same, I made the same assumption that sometimes it might be a smoother position of leadership to be from the same party. What past attorneys general have told me, though, ironically, is that sometimes it's just as difficult to be in your party because you get pressure to act a certain way, and that sometimes the most healthy type of relationship is to be from two different parties, because forces you to create a public framework that has to be transparent. You either choose to get along or sometimes have to fight, but you should do it in public in a way that the people of New Mexico can truly judge how the governor and the attorney general are performing. So interestingly, some of the Democratic attorneys general in the past told me that sometimes it was the most difficult to serve with a governor in their own party because of their own internal ambitions. And so, you know, I was a little surprised, but I would be willing to follow the rule of law. And on sometimes, whether the person's in my party or not, the attorney general sometimes has to side with the governor, and sometimes they have to side against the governor in the people's interests. So it's not an easy job, but I don't think that just being from the similar parties is a recipe for success. It's going to be a very difficult job for either one of us.
Okay. And Susan, I'd like you to talk a little bit about, we know that you worked with Governor Martinez for
years.
quite a while, I'm right?
Yes.
So how do you think your previous relationship with her is going to help or hurt you or influence you if you become Attorney General and she's reelected? And also talk a little bit about what might happen with you if you're serving and Gary King is governor.
Well, I think one of the things that Hector said that was really kind of interesting was that the past attorney generals he talked to talked about their own, I think it was their own ambitions. And I don't have any other ambitions other than to be attorney general. So I'm not going to be having to worry about what the party thinks about me or what the Democrats think about me or what the Republicans think about me. I only have to worry about what the people think about me because that's who I'm going to be representing all the time. That is the job. I think working with the governor for so many years, I think that makes it an easy thing for me to be a strong advisor for her. She was my boss for 14 years. I was her chief deputy district attorney, and she was the boss, the hiring and firing authority at the district attorney's office. And I gave her advice all the time there, sometimes not the advice that she wanted to hear. Because you don't do a good job in any leadership role if you don't have people who are willing to tell you no. So I know how to tell Governor Martinez no. I also know how to help her achieve the goal she wants to. If she's come up with a way that I don't think is the proper way to do it, I know how to help her get there as well. So I think that having people that know how to work together can only help the state, because, and particularly when the person in the attorney position who's supposed to be an advisor, not a conflictor, but somebody who's supposed to advise and make sure that advice is good and not just what somebody wants to hear. When they don't have any further political ambitions, I think that's the best scenario you could possibly think of. Works the same if Gary King becomes the governor. My job is to give him the proper advice when he's trying to achieve a goal. If I believe that goal is the proper goal we want to get to, if the path he's taking isn't the one that I think should be taken, then I think it's my job as a lawyer to try and help him find a path to that goal. Same way I would do with Governor Martinez.
Okay, thank you. Obviously, I have an interest in the way that the Attorney General views the press. And from my perspective as a newspaper editor, one of the most important things that the Attorney General does is enforce the state open records laws and Open Meetings Act. And, there have been some problems with various attorneys general and how they implement that law. And one of the things that Gary King's kind of taken it on the nose about is releasing emails between government officials that were from private addresses. Would you have handled that case in a manner differently, or that request in a different manner than it was handled?
Which one are you talking about? There's a couple of versions of...
The ones that were released were years ago.
Yeah, we're talking about 2010, and the collection of emails that flew between the Governor Martinez and some folks who worked on her campaign, and then subsequently became high-level officials in the government.
Well, are you going to me first?
Yeah, you're first.
I'm going to handle this
Right,
one.
yeah.
This one is a tricky one because I already believe that New Mexico gets an F when it comes to IPRA, public records disclosure, records retention. There's no clarity. There's different standards for different agencies. If you're in Mora versus the city of Albuquerque, you actually get different response times and different enforcement within those agencies. And so that's already kind of the backdrop for this email fiasco, that it's not clearly definable what is public record and what is not. I can tell you at the Attorney General's office, we would have more clarity when things become confidential versus when they're consistently public record. I thought that the federal reprimand of those emails and not knowing there was another investigation was a problem for the Attorney General. But secondly, yes, the presumption of public record, emails that are public record, the presumption should always be in favor of the taxpayer and in favor of transparency. But every email and communication in state government, whether it's the legislature or state agencies, has to have justifications for why things are not public record. And I think that that's where we would improve on explaining, these emails are not public record or they are public record, and with an articulated written justification of the policy. And right now there doesn't seem to be in written record AG policy on when things become confidential public record. So we would try to increase that and improve that.
Susan, how about you? Did he make the right call on that?
No, I mean, clearly he got there was a reprimand that came from the federal government. Yeah, that was just wrong. And I think that it's just a complete misunderstanding. There are actually, for any law, fairly clear regulatory rules on what emails agencies have to keep. if you work in government, you're still going to, maybe email the person on 3 floors up from you, hey, how are you this morning? Do you want to have a cup of coffee? We don't have to keep that email. The policies are trying to focus on emails that matter. So if you're creating policies, if you're discussing issues that might be subject to policy in the future, those kinds of things are supposed to be saved, not chatty emails. Now, we don't want agencies just chatting away or inserting chat into something and trying to call it, well, I wasn't really talking about that, I was just asking about coffee. But that's going to happen, and we do want people to at least be comfortable in their jobs. So those kinds of emails don't need to be saved, but the rules are really actually pretty clear. I think that where there may be a failure under IPRA is there's no different rules in Mora than there are in Albuquerque. You're supposed to behave the same. So is making sure the Attorney General's office can make sure that Mora is behaving the same as Albuquerque. And then what ultimately needs to come is confidence that the Attorney General's office is making sure that as much as can be disclosed is being disclosed without violating the rules, without violating individuals' rights, without violating somebody who's been accused of a crime but not charged with a crime's rights. All of those things that do allow things to be kept, and explaining precisely that. Not just coming out and saying, I'm not going to give those. I'm not going to give those because this is the exception that applies to these. Now, you can't explain it too thoroughly. I mean, if I'm keeping something because you've been accused of a crime but not yet charged with it, I can't really go, well, and here's why, because, there's a crime going in here. But then, it applies under this general rule because just by implying that, I could do a lot of damage. I think that's a real need for anyone in this position to understand the damage that can be done just by accusing someone. That comes from years of working with law enforcement. We know how careful that is. And that's important. I mean, the public's right to know is important, but if it was them, they would like that to be accurate information.
So I'm glad you brought up law enforcement in that answer, because that leads me to the next thing I wanted to ask.
We are good at that, aren't we?
Yeah,
I think we've done that every time.
Yeah.
It's great. So this is you first. And so we know that not all public agencies and not all public officials follow IPRA. I believe we have lots of examples of people in very recent history not following the law. So the way that our system is set up, the Attorney General can go to court on behalf of citizens who don't get records, but that very rarely happens. So as Attorney General, are you going to be willing to go to court for IPRA, or do you believe that really the requesters are supposed to bear this burden of penalty and enforcement?
I think that what I'd like to see happening, my vision of this is, because there's not a whole lot of penalty to not complying with IPRA, is to get a report from a citizen or whoever is requesting the information and sit down with that agency. Law enforcement agencies in particular struggle, I think, with IPRA because of their fear of releasing information that either may harm an investigation or may harm the reputation of a person. So I think they really struggle with that. I mean, I've worked with sheriffs statewide. In fact, a bunch of them are endorsing me, and we've talked a lot about the struggles that they have with these sorts of things. So you want to sit down and talk to them first. You want to kind of give them a warning system. Okay, this is how it needs to be done. This is where you didn't do it right. Let's fix that. And help them understand. Ultimately, yes, if they continue to make that error or continue to do what I believe is not comply with IPRA, yes, I think that it's our obligation to bring that to the attention, because it's hard for people. We don't want people to always have to go into court, and it's a complex law. And, if that's in the best interests of the people I represent, which is everybody in the state, is to make sure that this agency is in compliance and they haven't been able to take the advice and come into compliance, I absolutely think it's my obligation to take them to court, and maybe perhaps a judge explaining to them what needs to happen might help.
And how about you, Hector? Do you, are you going to be willing to go to court to enforce the penalties that exist in IPRA, or do you want to?
Absolutely, we will be. First, I think the agency needs to become a watchdog agency that's able to monitor the progress of IPRA transactions. And so properly documenting, properly training, and properly setting the high expectation that IPRA will be enforced is something that we're going to do. At the auditor's office, one of the most amazing transformations that we encountered was changing the culture of accountability, where citizens could call me, we would properly document, and then we would properly let the governing bodies know that they are out of compliance. I believe in two things: leading from the front and truth to camera, which means that your Attorney General should be able to tell the public which communities are not getting the best IPRA compliance, give them clear information about what the Attorney General is going to do, and then be able to act and make an impact. We're going to have that approach at the Attorney General's office, and I think you'll see a change in culture in IPRA. The other thing is that the legislature and the executive need to take responsibility for the lack of infrastructure to actually give the resources to enforce IPRA as well. For instance, there's a records custodian, but the legislature in their infinite wisdom has thousands of employee staff. They should statutorily mandate that the custodian also have the proper IPRA trained officers to make those requests turned around. This is a huge gap between agencies who comply with IPRA because they commit the right resources, the right training, and then those agencies that you're referring to that are somehow in the dark. So I think it's a two-pronged approach. The AG should be the hammer when they need to be the hammer, but also the governor and the legislature need to take responsibility about why there's too much opportunity for IPRA requests to just go by the wayside. We've known these dirty little secrets for years, but there hasn't been the type of accountability investment that I think needs to happen. And the Attorney General, either one of us could bring that debate to the legislature and the governor and say, look, we want to grow up when it comes to enforcing and actually executing IPRA requests.
Well, we're counting on both of you.